of Mr. Shetty's.
Yes, my lord.
One seven.
117. Annexure P9, 117, my lord. 3rd August 2017. My lords put that to me right in the beginning.
Yes.
So, my lords, may I just read this? This is issued by the Government of India, Ministry of Human Resources.
This will make everything clear.
Yes, my lords, I will. This is regarding training of untrained in-service elementary teachers in government, government-aided, unaided private schools. It is apprised that the amendment to Section 23(2) of the RTE Act to extend the period of such training to 31st March 2019 has been passed by the Parliament. So, my lords, all training had to be completed by 31st March 2019.
Insofar as in-service candidates are concerned.
Service candidates are concerned, all. And if they do not acquire it, they go out.
That we have at least repeated not less than half a dozen times.
I'm sorry.
You must have stated that 6 times. I must have stated that 6 times.
Yes, my lords, that's true. My lords, I also, we tend to get carried away by our only good points.
Yes.
Yeah.
That's not a good point.
I thought so, my lords. I hope so. I'm able to persuade. Further, it is reiterated that this will be last chance to acquire requisite minimum professional qualification. Any teacher in the aforementioned schools who does not have minimum qualification mandated under the RTE Act 2009 would not be allowed to continue.
Again, the intention is clear.
That's where my lords may look at it one way. I look at it from a point that this was my cut-off deadline. If I did not...
This was not cut-off here. This was a cut-off deadline.
If I...
You are either on this side of the gate or that side of the gate.
So I'm in this...
It doesn't bring you on par with the 2-year diploma holders.
My lords, with respect, I will be able to satisfy you.
And you argue on that point.
So I'm going to come. Can I just take you through the...
This we are clear.
No, my lords, there is a little bit here, if I may just show to my lords, that the government itself structured the NIOS. It came out with this...
It structured, it did everything. It did everything under the sky which could be done so as to protect those who are in service and get them training. It is only with an intention that they should not be thrown out.
My lords, can I just put it...
This is a relaxation granted to you under the rules. It doesn't take place of the regulations which prescribes a minimum qualification.
My lords, can I say this? That once I...
Otherwise, the regulations which prescribe the minimum qualification are required to be thrown in dustbin.
Yes. So, my lords, it is not my case.
They will be terminated from after.
My lords...
The very intention of this HRD direction is very clear. By 31st of March 19,
I'm grateful.
You complete the qualification, a special procedure is made so that you are granted around 2 years period to complete that. If you don't do that, you are out of service. If you complete that, you are in service.
Absolutely.
So the very intention is to protect you where you are, not to provide you with a qualification which is prescribed under the regulations.
My lords, can I...
Yes, thank you.
My lords, please. I think I have something here to add. Just give me that few minutes. I wanted to read page 118 and couple of more provisions, and I think my response to my lord's query is this. It is my submission. It was the intention.
You read the entire clause. Every line you read, it will be clear that it is only in order to protect you where you are.
My lords, I will, on one aspect, I respectfully beg to make a submission different from the manner in which my lords are putting it. And my submission is this, that when I read this and I read it with the one which the NCTE has passed, what it prescribed was...
NCTE could not have gone beyond this.
My lords,
NCTE was only bound to comply with these directions.
Yes, absolutely. So if my lords, my submission is this. Just let me formulate that and show you those 2-3 provisions, and then my lords may take the view. The submission is this. The government undoubtedly fixed a deadline of 31st March 2019 for people in service to acquire qualification.
So as to continue in service where you are.
Continue. No, I would beg to differ there, because I would say if I did not acquire the qualification, I get thrown out. Now, therefore, the minute I acquire the qualification,
Are you,
I come
what
at
is-
par.
are you-
I come at par.
are you relying on any judgments for that?
My lords, this is very clear in itself. Can I please read it further? I will show the other two authorities, and Tripura and the others took a view on this.
We are not bound by Tripura and.
My lords, they relied. Yes.
I appear for the Ramsar and Moriarty's case. This
You are appearing for
NCTE.
NCTE, yes.
Ramsar and Moriarty's case, this honorable court has validated the same notification. So I would take my lords to page some certain paragraphs of Ramsar and Moria, which will clear the picture for my lords also. But,
After she finishes,
My lords, just little bit. Let me just put this so that I am through, and then my learned friend can show that. Now, my lords, my submission, if I put it, is this. It is my case that when I acquire the qualification through the NCTE method of NIOS, under the MHRD direction, I get what is a Deled qualification, which is recognized by the Ministry of Human Resource, recognized by NCTE. When I get that particular qualification, I am qualified as any other person. At that point in time, it could have been the government's intention. Where would they get 11 lakh teachers from? Teachers had experience, they had been teaching, but then by which time NCTE had formulated for primary teachers a particular course. It was necessary to bring the existing teachers in line with what was required. But once I qualified, I passed this particular exam, I carried out this particular course, I am no different from anyone else. It is not a
please
matter.
substantiate their arguments. Please substantiate their arguments.
My lords, there. Yes, please, can we come to page 118? Please come to serial number 4 there. And few other clauses in this. My lords, have page 118, serial number 4. It is mandatory for all in-service untrained teachers to take Deled program. My lords, I am emphasizing on the word Deled program. So I am getting my Deled qualification is what I am emphasizing on. Through OM on NIOS, unless they are already enrolled and undergoing training in a recognized teacher education institute prior to amendment. So it is mandatory for them to take the Deled program. Now, if my lords may go further on this aspect, please see the method is prescribed for Deled, page number 119. For creation of database, on the top of the page, serial number Roman 8, untrained elementary teachers for Deled. There will be online portal of NIOS. So all these teachers are going in for a training which will be Deled program. My lords may turn to next page 120. Teachers who do not fulfill the minimum eligibility criteria.
Or rather that last clause on page 119.
Please, my lords, absolutely. The unqualified teachers in government-aided private school who fail to enroll before 15 September are liable to face removal, dismissal. My lords, that is so because the government wanted the implementation of the RTE Act. The teachers have to be trained. Once I undergo the training, my lords are looking at an advertisement that is issued subsequently after my training. Now, once I've undergone the training, I've got the Deled program through NIOS. I am as good in Deled as any other candidates vying for the government job. How am I different from anybody else is a question that I would then ask myself.
The difference is that they have undergone 2 years physical course and you have undergone 18 months postal course.
My lords.
And they have, and their 2 years also, after 2 years, they are inclined to, they are required to have 6 months training.
Yes. So, my lords.
You can't equate them with that.
I will answer that squarely. It is an NCTE.
If you are relying on anything, please rely now. I think we have
Yeah.
heard it
Because
sufficiently.
It is NCTE. Give me this part which you want to push. This is that part of the. Yes. But this is the other matter. This matter only. My lords, these are additional documents in IA number 146088 of 2023. Yes, in the same matter.
Why don't you provide us convenience compilations?
Yes, my lords, we should have. And this is a part of the Gazette. This is this Gazette, right? It starts here. My lords, page 237, appendix 9. This is the appendix to the NCTE.
237.
Page 237.
Appendix
There is
9.
no.
Please, my lords.
From 236, there is directly 237A in my copy.
My lords, is there a page 237 which is a part of a Gazette of India?
My learned brothers, it is there.
My lords, can I pass on my Gazette copy itself? I have the full Gazette with me.
It's there. 237A is first and then 237.
Oh, I see. There's somebody else. These are norms for standard diploma in elementary education program through open distance learning system leading to diploma in elementary education. And the preamble. The elementary teacher education program through open and distance learning system is intended primarily for upgrading the professional competence of
Working in service teachers.
My lords,
Okay.
yes. But my lords, once I go through with it,
Okay, if you are arguing the same thing again and again, rather than repeating the same argument, if you can substantiate your argument with some legal submissions, we can understand. This is taking us nowhere. Again and again, on the contrary, the emphasis that in service. So as to the emphasis of the directions of the MHRD, it's clear that rather than throwing these persons who are not in tune with the provisions of section 23 of the RT Act, provide them a window so that they can get qualified and can remain in their service.
my lords,
But if you are arguing that once you get benefit of that relaxation and get that diploma, then you are par with all others. Then unless you substantiate that argument, there's no point in doing again the same things.
my lords, but that I can only substantiate through the notification of the NCTE that I have read.
And that I think Ms. Karya would do it better.
Yeah, I have read it from there, and I have said that NCTE itself recognizes that.
So we'll decide. We'll ask the NCTE what their stand is.
My lords,
Otherwise, it is taking us no further that you are repeating the same thing again and again. That once you are get through, you are equal.
Let them read and explain. So, my lords, only I ended by saying that today the issue before my lords is, as I have shown, that their case is only whether the NIOS is the agency that could have given me the delay. The case in that document
And
is
then the another condition is that if suppose the employer, even if there is a minimum prescription under the even say the this act, are not entitled to impose a further qualification
absolutely they
as
are.
an employer.
They are, but in the advertisement,
Unless it is found to be arbitrary, malafide.
no issue there. But my lords, the advertisement only requires deled.
No, DA through so and a recognized institute.
My lords, recognized institute or by NCTE, NCTE recognizes NIOS. That is my case.
So we'll ask them whether
Yes.
they recognize
So-
NIOS only for a limited purpose or for all the purposes.
My lords, this NIOS was conducted for.
What is your stand, Madam Karya?
Till 2019. not beyond that.
No, no, and only for those persons who are in service.
Absolutely, my lord. Those are in service.
And in order to protect their services.
You may come here.
What has happened is, as per Regulation 9, just to answer my lord's that question, where it supports from the NCTE regulation, Regulation 9 of NCTE Regulation 2014. I can pass on my copy. Unfortunately, I'm so sorry that copy is not there.
It is not on record.
It is not on the record. It is a NCTE Act and Regulation, my lord. The NCTE Regulation 9 of NCTE 2014 will stipulate norms and standards for various education programs as specified in Appendix 15. I'm so sorry, my lords. I do not have
2014 revision clause.
NCTE Regulation 2014, my lords.
Recognition norms and procedure regulation.
Yes, my lord. Yes. Appendix
Which clause?
9 to that, the one which I'm showing the page, the same page.
Appendix 9.
Yes, my lords. The serial number 9, my lords. Same page, serial number 9, my lords. The page which I had opened for my lords, the serial number 9.
Yes.
Diploma in elementary.
Norms and standards.
Yes, my lords. Norms and standard, the serial 9 in that.
Diploma in.
Yes. Diploma in elementary education program through open and distance learning system leading to diploma in elementary education. The DED is categorically enlisted, which refers to Appendix 9. So that to support, we received the direction from central government under 29A, and then under exercising power under 12A, this notification was issued. Well, this notification has been validated based on record in Raman Moria's case.
Which notification? This MHRD?
Yes, my lord. The very same notification. I'll just give para 40.
No, this
have the judgment.
No, this
Para
is not under section 12A.
That's also under section 12, my lord. This notification is.
Yes.
We can only pass this notification.
3rd August 2017.
Yes, my lord.
Where does it refer to 12A?
Exercising the power 12.
Page 117.
117. Of Nandan or Ram. Okay, they are in
So therefore,
there is no source of power mentioned in this, because this is not a notification, this is
NCTE
only a letter,
to
communication.
modify or to do anything under 12A only. Beyond that,
12A,
power.
12A reduce 32 do DD.
We are, but this is under 12A, my lords.
How can it is no source of power mentioned?
I'll read.
True, it is that even if source of power is not mentioned, the government can do it, and the source of power can be traced later on, but it must be emanating from the concerned required authority. That if section 12A power is to be exercised, the notification has to be in its particular form. It can't be by way of a letter.
Just refer, I'll read out section 29A, 29 for
the NCT.
NCTE Act.
I'll just give it to you. My act was here. It must be here. It's here. It's here. You take yours. And I'll take those ones.
Yes, 29, direction by the central government.
Yes, my lords.
Here, I have it. Where are notes? Here it is. My pockets. Oh.
The national, my lords are there at para 44, my lords. The National Councils for Teachers Education Act 1993 was enacted inter alia to provide for the regulations for proper maintenance of norms and standards in the teachers' education system. Chapter 2 of the NCTE Act deals with the establishment of the council, while Chapter 3 deals with the functions of the council, and some of the functions of the councils are laid down in Section 12 are as under. Functions of the council: it shall be the duty of the council to take all such steps as it may think fit for ensuring planned and coordinated development of teachers' education and for the determination of maintenance of standards for teachers' education and for the purpose of performing its function. Under this Act, the Council may C. Coordinate and monitor teachers' education and its development in the country, lay down guidelines in respect of minimum qualification for a person to be employed as a teacher in the school or in recognized institution, lay down norms for any specified category of a course or trainings in teachers' education, including the minimum eligibility criteria for the admission thereof and the method of selection of candidates, duration of the course, contents of and mode of curriculum. Willows then can have 44.1. NCTE Act as originally enacted was primarily concerned with regulating standards in teacher education system. The provisions of the NCTE Act came up for consideration in state of Maharashtra versus Sant Jnaneshwar. Para 62 has been reproduced there. Whereas I'm not reading that. I'm taking Millards further. The basic education, UP.
What are the facts for consideration in that Ramsur?
It's very this notification, which was
17 notification.
Yes, my lord. That notification is under challenge.
17 stands clarified in 19th Communication 164. It cannot, I mean, somehow there has to be a proper statute of the code. Lordship 164. 164 Lordship. It stands clarified 2 years later. You remain confined to this enabling provision relaxation. This cannot be relaxed. Lordship 164. There should be straight and honest to the court.
Minimum qualification regulation has never
Not
been
in,
amended.
yes.
Unless that is amended to insert this qualification of 18 months program as equivalent
The issue,
2 year.
we are reading Ram Suraj Moria out of context. The issue in before Ram Suraj Moria was the eligibility of Shikshan. Shikshan, what is called? Shikshan Mitra. To be appointed as a regular assistant teacher. This issue was not there.
No, my lords, but then the one which had taken the training of 6 months were also to be allowed as a primary teacher by Ramsar and Moria. And it is the similar case here that we are allowing them by the correspondence course. And
What was your stand in the counter before the High Court?
My lords, we were relying on the Patna High Court. We have not challenged
What
the
was-
High Court judgment, and we support the notification.
Support the cancellation notification.
No, not cancellation.
Then
We agree with the Patna view taken by the Patna High Court.
agreed.
We
They
agree.
did not come to the High Court.
Agree.
No, they did not.
No,
agree, we
you see,
agree.
you have to take an
Yes,
independent
we have not
step.
challenged. So we
Why
have
does that-
Before Uttarakhand High Court, you cannot say that we agree with the Patna High Court, therefore we have no stand.
because we had not
What the order
challenged.
says.
You have to take a definite stand.
Lordship.
We agree with the Patna High Court.
Otherwise, we will say that NCTE has no stand before this court. And you are telling us to follow Patna High Court. How can you tell us to follow Patna High Court in
Section
SLP?
29 is something which, my lords, I'll take it through. Directions by the central government, because these were the directions by the central governments for us to allow these people to participate. So that's why this course was also in,
Where is the direction by the central government to allow them to participate in the selection process?
not in the selection process, but to
Direction is
regulate
only to provide a window
window.
to them so that they are not out of employment. If you read the MHRD direction, it is very clear that
I bow down my lords.
to bring in tune with section 23, a window has to be provided that before 31st of March 2021, 19, they acquire a qualification so that they continue to the service, otherwise they will be thrown out.
Lords, but once they have acquired the qualification, then they were permitted to participate also. Otherwise, acquiring this qualification becomes an future, and the number of
Why acquiring the qualification becomes relevant, otherwise they would have been out of the service.
So otherwise also those who have acquired the qualification, if they continue to in the services, this was required. And if they are allowed to participate in this process, we'll get the better quality of the teacher. That is the whole purpose of
How is the better quality? A quality of a teacher who has undergone a 2 years regular course.
Now, they're all in service. They're experienced teacher, my lords. They're all in
And
service.
if the state wants to prescribe a better qualification,
That we cannot stop. But at the same time, this is the minimum qualification which also can be considered. That they have not even prescribed more than DA.
It is not even notified. As required in 23(1).
Notification accepting Patna High Court, page 30 to 30. This is in our count. This is the NCTE.
Lord's NCTE notification, so agreeing to the Patna High Court review taken is that
She should assist the court properly. It's not a notification, it's a government. Lordship may have the order 171. What is that order?
It is what else you will call it then? Notification then? What?
No, please, it's a letter, please.
Notification has a definite connotation, man.
178.
Every
Letter. Myself. This is the council's letter.
Letter.
It's at page 30 of the counter affidavit because of
NCTE.
respond number 1. In Nandan Singh's case. Nandan Singh, Ashish Kumar. Because we are bound by the central government's direction under the
central government's direction was only to provide a special window for training for.
You see, where is this direction that this qualification of 18th month training program under distance learning mode would be equivalent to the 2-year diploma course? Where is this direction? Tell us, either by the central government or by the council.
They are admitting it's a Patna High Court, they are complying with.
And unless you do so, court by the process of the judicial interpretation cannot provide equivalence. There are judgments to this effect. And the law is settled that we cannot equate two qualifications. That is of the either by the recruiting body or the academic body.
This recognition order is at page 130 of the state's SLP methods. I'm so sorry, it's all over.
130. It's same which
Yes,
Arora was reading.
Yes, last paragraph.
Ah.
That's the only legally reliable.
This is exactly this recognition order.
Yes, madam. Clause 133, para 8. This program shall be only for those in service untrained teachers in government aided and private unaided school appointed on or before 10/8/2017. All the provisions in NCTE Act and Regulation 2014, other than those relaxed under Section 12 of NCTE Regulation, will be applicable. Let's further at page 241. Because they validated that 6 months course and allowed the Shikshak Mitra course also to participate. because there is a lack of teachers in for the primary education.
If there is a lack of teachers. Here, there is not a case of lack of teachers. There are plenty of teachers available.
Please, one aspect that I have because my learned friend took over on this point. The point of the B.Ed is now decided by this court, and this court has held that B.Ed people are not qualified for the post.
So we are not concerned with that. We are only concerned whether you are qualified or not.
My lord, but that aspect is there. They have taken that issue. So I just must point out that this court.
We are not concerned with that issue.
That Justice Dhulia's order.
B.Ed are not entitled for primary school. Primary school is a specific D.Ed.
Yes.
That is the prospect.
There the dispute was about B.Ed and D.Ed. Here the dispute is about 18 months and 2 years.
Yes, but here also they want
Totally
to take
different, totally different.
No, my lords, but here also they want to take B.Ed people, so that cannot
They
be
have
done
already been
today
appointed.
because
But that was not the challenge here.
Yes.
That was not the challenge here. To take us to a different.
Item 39, it was fixed for today. Today it might not reach, or it may not get over also if it reaches later. So, Lord, instead of today, could it be taken on 28th of November, Tuesday? By consent, the other side is.
Yes, I'm appearing on behalf of the respondents.
No. 20th.
My lord,
Obliged.
similar request, Mr. Parekh begs leave to be unmuted. He's under the weather today. He has high fever. In item 23, we've informed all the AORs to the other side. If it could be taken up after Diwali, my lord.
We have only one matter with respect to Shimla Development Plan. And
Yes, sir.
Is there any?
yes, sir. We have prepared the plan, notified it, but we are not able to implement this. Options have already observed and not implemented the next week.
No.
My lord, they have themselves sought adjournments on previous. But today it's to ill health. Any date, my lord.
Any date after.
May I see just one in we are not in adversarial litigation. This is the interest of the state and every citizen. Since the past 6-7 years, no development activity has been possible because of the NCTE. The citizens, even unsafe and unfit buildings, we are not able to sanction them. People are living in those buildings. At the same time, they say people are living in those buildings, they are falling. And now those buildings, because we can't do anything about it, in definitely the Lordship's direction, we have not implemented the plan. We are not accepting any plan. The Lordship may kindly just permit us to accept them and we will not finalize them. They accept them.
We'll take it immediately after vacation.
Yes.
We'll hear you and pass an order. When is the learned AG?
I would be available at my lord's, subject to my lord's convenience.
छुट्टी के बाद एक Tuesday को रख दीजिए. I on board.
Please, Your Honor.
Plus, I have one provision to read is section 12A, which has a power. First, I can take you to the recognition order, which is at page 130.
130
of the Nandan Singh's paper book. Nandan Singh SLP.
State SFL.
State SL, sorry. Plus 131 is the relevant. Para 2 on, I will just read. And whereas in view, well, are there, at page 131, the recognition order by NCTE for this NBS sportsman. 131 is a relevant para sec 2. It starts at and whereas in view of the above mentioned direction of the Ministry of Human Resource Development under section 29 of the NCTE Act and after considering recommendations of expert committee, after considering all recommendation of expert committee, chairperson of NCTE exercise of his power under clause 12 of the NCTE recognition norm and procedure regulation 2014 granted relaxation by NCTE headquarters letter dated so and so to the following provisions in the NCTE regulation 2014 for ensuring that the directives of the NHRD for implementing the amendment to the RTE Act 2019 are duly fulfilled. In that, my lords, the second one is important. Any provision related to to the duration of the program.
So this has to be read with reference to the directions of the MHRD.
Yes.
And the directions of MHRD are for a specific purpose. So as to provide a window to the persons who are already in employment and that they don't get out of employment by 31st of March 2019. So it will have to be read in that context. It can't be read in isolation.
Now down, my lords, what has happened since we reduced that course to 18 months and provided it online and duly recognized, many states offer that, many people appeared for that. And that's where the problem started and everybody approached the different high courts. So Patna High Court and Tripura High Court allowed them to do so. And those orders were not challenged. That's been the stand of NCTE.
On the contrary, NCTE should have challenged those orders.
They had not, unfortunately.
Yes, it's unfortunate. How could a relaxation for a specific purpose be used to give them equal status?
No, because they were in service experience.
So in service for the limited purpose of protecting their service.
Absolutely. I'm not arguing on that.
So the MHR direction, the HRD direction is only with that regard.
I bowed on that. That's the only limited submission I have. I do not want to waste court time.
Thank you.
I'll just take 5 minutes just for your lordships to consider the...
You are appearing for?
Well, I am appearing for the impeded parties. We were in the writ petition ourselves, but we were not made parties here.
Impeded parties means
We are,
or 18 months or
18 months. To be clear, we had 18 months, people in private service, and we are arguing that we should be allowed to apply. Your lordships have repeatedly said, and I think we can't go beyond that, your lordships have said that the power, I implied at least in what your lordships are saying, that the power to relax is there. And the power to relax on the basis of what the government of India has said, that power has been exercised. But as your lordship said, for a limited purpose. These were people in service. They should not be knocked out of service because there was a limited time within which your lordships have rightly said. That your jobs should be secured. You should not be thrown out of a job overnight. Well, the limited purpose may well be achieved, but it's achieved because your lordships are recognizing the right to relax, etc., or the duty to relax. Well, what happens with us is we don't lose our job, but it's only once that this exception was being made. It was not for all times to come. So it was only being made now for us. We will retain our jobs, but we will not have the right to apply to get into a better job, i.e. a government job. Well, for that, I'm only seeking your lordships to consider whether a purposive interpretation of that document can be done as to what is the indication for power to relax. Is it to put you on power, which some reading might suggest that you're on par with the 2-year course, or it is only specifically, as your lordships have said, to protect you in your jobs. And my lords, considering the fact, as your lordships have observed, that the orders of the 2 high courts were not challenged, and they were proceeded with in the manner in which we are trying to argue we should have been proceeded with, and the High Court in Uttarakhand has in fact proceeded with it. My lords, that would create 2 classes of people, one who have this on par with the 2-year course, and one who will if your lordships go against us, would not be on par with the 2-year course. So, my lords, I'm only seeking that your lordships look at it purposively to see that this was not a permanent solution. It was just a solution for a specific time and place where there was no way that we could have been told to go into a 2-year course because the time was not available. Retrospective application.
Specific purpose.
What is the purpose? Your purpose, your lordship.
Specific measure for specific purpose.
Well, if your lordships come to that conclusion, then really I can't argue any further that this was limited to the purpose that your job should not be taken away from you. But if it was for the purpose, and asking your lordships or urging your lordships to consider it purposively, that this would amount to implied equivalent who have a two-year qualification. If you want to apply, you will be able to apply, etc. Otherwise, we'll have a job for the rest of our lives, but we will never be able to apply. Even in future, we will not be able to apply because we would artificially be put in a little bubble where we have a job, but we have no prospects of going further. Everybody else who are with us, who have been with us, have been teaching with us, have the same experience. If they have the two-year course, they will go. And that will done. I don't know whether the government will think of another notification where the course by distant education will be made into a two-year course or not, but it is already over. That was only for that particular period. So it was okay. I'm grateful, Malaj. It was over. It's now over. There is no proposition now. And being over, it means I will never be able to apply for a job because my equivalence and that course will not introduced for you. Well, you will be thrown out of the job. Well, and only to protect you in the job, that special window was opened. Right. Thank you, Manoj. And we are grateful to the government for having done that. So our job, even people who were in the government service who were government teachers who didn't have the qualification would have got the qualification and remain where they were. They will continue as government teachers. But I will not have any further prospects because as far as I'm concerned, your lordship will treat it as one-time solution to leave me in the job, rather than put me on par with anybody else who would apply, selected or get rejected on this basis. So I will be denied the opportunity of a job. That is the critical matter if your lordship interpreted in one way, and if your lordship interpreted it purposively, then I would be able to apply for the government jobs in future. How would be purposeful interpretation of the principle of purposeful interpretation applicable? Well, I'm grateful. All I'm saying is that at that time, when the government gave on the contrary, if you apply the principle of purposeful interpretation, the interpretation will be against you. The purpose was that the persons are in job, they are without qualification, in view of the RT Act and particularly Section 23 thereof, if they don't acquire the requisite qualification within a particular time, they will be out of job. Yes. And with that purpose in mind, the government came out with a special scheme, the object of which was to protect you in your employment. Well, that's your lordship reading on that document is that this was the limited purpose. But the several documents that Mr. Arora read to you, lordships, they all deal with it in terms of several documents only lead to that conclusion, and it basically emanates from the direction of HRD. Well, it emanates from the direction of HRD. Direction of the HRD is saying that this is the immediate concern. But in all fairness, my lords, the HRD didn't say that this is our limited concern, that you take care of their job now, no future prospects. This is only for a limited purpose. But as your lordships read, it obviously reads like this is what they were wanting to address. But were they wanting to address it in a manner, I ask myself, that cut off all opportunities for future for me? That is what document says. The protection in present day would not mean opportunity in future. Well, I understand. But there are two different things. But your lordship will consider that people placed in my position, whether they are in Odisha or they are in Bihar, would be able to apply. They would have already applied, possibly got jobs, and they will apply in future as well. If I have a future opportunity, I still will not be able to apply unless, of course, I resign from my job or take leave and go and go and do the course for 2 years. I will not have the opportunity. They have got the opportunity because of a wrong judgment of a high court. We cannot be made to follow that. Would your lordship hold it against me? You cannot rely upon a wrong judgment, which according to us, not subject to whatever we decide. Well, if your lordships come to that conclusion, obviously there is no opportunity. But all I'm saying is that this has no domino effect. This will not be something that concerns people who will come after us. It will be only for a limited persons, only once that this is done, which was the intention of NCTE, but they have unfortunately at that time not thought of that not only should we give them an opportunity to stay in the job, but also provide an equivalence. So what I'm saying is would your lordships be able to consider, if possible, consider that there's an implied equivalence, if not a specific, explicit equivalence of one course with the other? That, of course, my lords, is an exercise normally which is done where an authority sits down, compares the qualifications, and then comes to a conclusion that this is an equivalent. But in the manner in which this thing has been processed and has proceeded, I would urge your lordships to consider whether there could be implied equivalence for the 18-month online course.
In the absence of minimum qualification regulation for recruitment as teachers, if there would have been no such regulation, probably we may. There is a regulation in place.
For which purpose?
How can we provide for a read implied equivalent which is contrary to the regulation?
Well, but for which purpose? I'm only asking your lordships to look at the regulation 12. Regulation 12, which gives the power. Regulation 12 that gives the power to exempt.
And we have not heard of any such principle like this implied equivalence.
Well, you haven't, but I'm urging, because this seems like a very unique case. Something like this should have.
The unique principle you want us to.
Well, but your lordships lay down. Your lordships are developing principles all the time.
Every day. Law is evolving.
Law is evolving.
Or organic.
It's only when your lordships see that there is merit, your lordship will consider.
We don't want to devolve.
Something like evolve. Because I'm only seeking evolution. I'm not seeking devolution. Well, it's your lordships develop outstanding jurisprudence when your lordships brought in curative petitions, right? Nobody had heard of, and in fact, world over, nobody has heard of something of that nature, beyond review, beyond reconsideration, etc. But your lordships did, because they may well have been a case that was promising, that was persuasive, and your lordships thought, to do justice, let us find a way out, and your lordships have. Similarly, I'm seeking in this case, my lords, to do justice to a case of people who are not in any way responsible for what has happened. Your lordships are saying the judgment of the High Court, which may be wrong, cannot sustain this. But my lords, what chance did I have? I was given an opportunity to go and do an 18-month course. I did the 18-month course. I applied in due course. There was, in fact, an order, the government order of the government, which clearly said that I had a right to apply. They then, of course, on reflection, changed their mind.
We may or may not accept you, but you are in the right track.
Well, I'm grateful that
argument-wise,
I'm grateful that at least up to this point,
legally probably,
at least up to this point that I've been able to come, and then, well, Lords, ultimately, your lordship will look at the fact that this is only one group of people. Their whole life career depends on this. What your lordships will finally decide, even if your lordships were to show displeasure in the manner in which.
Only one question.
Well, Lords.
You are asking about what will happen to their life. If the NCTE would not have come with this window and provided that 18 months course to you, what would have happened to their life on 31st of March 2019?
Because we would have been out, but your lordship knows so many teachers going out is not a good thing either for the state or for the country.
So they have been protected, and they should continue where they are.
And therefore, well, I only urge your lordships to consider whether this protection should come with offering something to me and then taking back an opportunity for lifetime, for future. Therefore, I'll be stuck where I am. That's all I'm seeking your lordships to consider when your lordships take a final view. I'm deeply grateful, my lords.
Only I'll take 2 minutes, Lord. The idea of getting this training was to bring all these incumbents within the fold of the rules in question. And the fact of the matter is that once they have been brought within the fold of the rules in question, my lord, they stand on the same footing. As of today, my lord, in regard to the institution in question, it is true that it was a specific purpose scheme under which I have got the training in question. But fact of the matter is that under the rules in question, as of now, I am to be treated as a duly eligible candidate in question. That is why, my lord, your lordship will kindly see that the central government, the Ministry of Home, at page 241 proceeded to write a letter to the council in question, Lord, asking them to consider the claim. And pursuant to this, the directive in question was issued, my lord. That letter is at page 241 and page 242. which clearly proceeds with, therefore, in this backdrop, it is required to issue a clarification.
What do you want of which matter?
It is the same states matter, my lord. It is at page 241 and page 242. It's a letter, my lord, request for TET DLD by NIOS cleared candidates of Uttarakhand. It is by Ministry of Education, Government of India, my lord. Department of School Education and Literacy. Request for TET DLD by NIOS cleared candidates of Uttarakhand state to allow them to apply for new vacancies of state teachers declared by the state in line of the state of Bihar. So this was a letter written by the central government, my lord, exercise of its power under section 29. I am directed to refer to a letter dated 16 November 2000 received from Uttarakhand NIOS Deled Teachers Association on the subject mentioned above. It has been requested that the teachers of Uttarakhand who have completed delayed course from NIOS may be made eligible to apply for new vacancies declared by the state in lines of the state of Bihar. It would be pertinent to mention here that High Court of Bihar in so and so has cleared teachers working in government-aided private and school to allow for appointment as elementary teachers training degree will be considered as a recognized degree for the same. Further, the department and city accepted decision on Honorable High Court and decided not to file any appeal against this. Therefore, in this backdrop, it is required to issue a clarification to all states and UTs. Those candidates who have completed delayed course of NIOS may be given opportunity to apply for fresh recruitment at par with other delayed candidates, subject to adherence to all other criteria and qualification requirements such as passing, TET, etc. So the central government has proceeded to write this letter, pursuant to which everything in question has been accepted, and even the state of Uttarakhand proceeded to accept the same. And subsequently, they have tried to rescind the same. This letter is very important, my lord, because it's a letter of the central government.
Yes.
And your lordship will also see, my lord, that to take a call on the question of equivalence, it is the competent authority is the NCTE. The NCTE has taken a call that it is equivalent. Once the NCTE, that is the competent authority under the act in question, has taken a call, that your lordship will kindly find, my lord, where the NCTE has been conferred with authority to take a call on the issue of, that is at page 104. Clause 5, interpretation. If any question arises relating to interpretation of these regulations or equivalence of various teachers training program, the council shall So once there is a directive of the central government, my lord, pursuant thereto, the council has taken a call. Pursuant thereto, my lord, the High Court has proceeded to pass an order that our claim in question, our candidature in question should also be considered. I submit, my lord, that once we are falling within the scope and ambit of the rules in question, because whatever rules are applicable, the institution in question wherein currently I am assigning my duties, my lord, they are covered by the same set of rules. In case I am not permitted to undertake any future exam, it will be blocking my road, my lord. So in that perspective, I respectfully pray, my lord. There is no infirmity in the order that has been passed. That is all, my lord. God bless you.
No, but whether NCTE issued any communication after this?
Yes, they have issued a communication.
Where is this? Where is that?
I'll just.
Page 250 methods of the same essay.
Page 250.
These what?
250, my lord. It's dated 6 January 2021. It is addressed to the Chief Secretary, all state UT government as per list. The subject is validity of DED program conducted by NIOS for training of untrained in-service elementary teachers regulation. And the letter in question of the ministry is referred, and then this directive is in question is issued. And that is why the state of Uttarakhand proceeded to accept it, but subsequently, in their wisdom, they have chosen to recall it.
Then why the regulation was not amended?
I'm very thankful to my friend for point.
1 minute, Mr. Let him complete.
It was a decision of the government. The central government's directive is to be complied with by the council as per section 29. And that is what the council did, my lord.
See, when the field is occupied by framing a regulation, a statutory regulation,
That is
there cannot be any direction
Oh, that-
on the administrative side.
what it's not on administrative side, not the
It is
central.
administrative side.
The central government has taken a policy decision, my
It
lord.
would have, central government could have amended the regulation.
It is the same central government that has taken a
Who
call.
stopped the central government?
On the at the first instance, my lord, certainly we were going out, so training was important. This is the second now model when fresh opportunity of getting employment, my lord, that has been blocked. That is
Yes, you were saying.
just a
Lordship may have the letter, my friend, I'm very
May I
thankful,
speak,
Mr.
Lord?
Shukla.
Yes, yes.
This letter of
Mr. Aruna wanted to add something. You were saying.
6.
Yes, Your Lordship. You are also appearing.
Yes. As per for similarly situated applicants, we were the original writ petitioners before the High Court. Now, by way of 3rd May order, Your Lordships allowed my statement. Because I'm not going to trouble Your Lordships with the constitutional scheme. Knows that under list 3, education falls, and there is a central legislation which occupies the field. In terms of section 23, Your Lordships have seen all that. I will not repeat anything. I just wish to propound on 2 points. If in 2018 or 2019, I would have known that instead of this 1.5 year course, I had to do the 2-year course, I would have possibly left my job, done that and applied. I can only look up to one authority, and that is the NCTE. I looked up to them, they said you are entitled to do it. I did it, I participated in it. That Your Lordships will keep in mind. Second, today there are 3 buckets of people that are before Your Lordships.
No, but the NCTE did it only with the direction of in pursuant to the direction of HRD,
That's
only
right.
in order to protect your services,
That's right.
not for any other purpose.
But I would respectfully submit, that though this is the purpose that Your Lordships are interpreting it to be, but according to us, it entitles us to also, though that's an argument, it also entitles us to participate. There is no exception in that document for that. If I am entitled to hold on to a post, there is no law which can prohibit me to apply for it. Today, Your Lordships are sitting in a jurisdiction where my lords will decide fate of 3 classes of people. First are those, and this case certainly arises out of a fascination for government job. Please appreciate that. Today, there are certain set of teachers who are already in a government job, they are holding a post. They were also equally protected by this order. There are certain people, who will apply afresh. Certainly, they have to have that 2-year DLED course. No difficulty there as well. Third is our category, we fall in the private school. Now, if the interpretation that Your Lordships are proposing to accept is accepted, tomorrow, even for the existing government assistant teachers, there will be no opportunity without leaving their job, doing a 2-year course, then applying again. So what essentially is
If a government teacher who has got benefit of that scheme and has been
kept in service,
and if there is any post for headmaster subsequently which requires particular qualification, then he will be debarred from that.
That's right.
The only purpose was to protect them so that they don't come on road.
I'm only placing for Your Lordship. Of course, we are at a position where we can only request Your Lordship to also consider our fate. Where, of course, they would not sort of demote themselves from coming from government to private. But we are the only exceptional cases which are left out, who were told that, who were at least shown this hope of doing a 1.5 year course and then possibly be eligible to apply.
The only hope was shown was that if you do this course, your services will not be terminated.
Well, we took it, and rightly or wrongly, it was nobody who stopped us from it. We took it to be at par. Great.
Thank you.
Let me respond to his submission that he would have resigned and gone for the course. He was perfectly aware that this is a course, it's a program to enable him to continue. It was relaxation. This order was issued way back in 2017. Thereafter, in 2019 and 20, the advertisements were made for the selection to the post. They continued to submit, they did not put a challenge to the selection proceedings. As of today, they say, they woke up in 2021 when this NCTE came out with this circular. They did not challenge this. Look here, I'm also qualified at par with this B.Ed and DL here. They kept silent, they never put up challenge to the advertisement, which continues to survive. Now I'm very thankful to Justice, my friend Mr. Shukla. Lordship, I am 178 of my, this pointing out this order to the court. Your paper book. My paper book. Why don't you refer from this paper book and it? Huh? What is it? This is Jaibir. Mr. Shukla read out the direction by the NCTE to chief secretaries. I'm very thankful.
Yes.
They have no case. After this, they have 241, 250, 241 and 250. 41. Their Mr. State's appeal. He read 241 and 250. And on the 6th of January. 6th of January. That is 250. 250. Now, he is relying on this. Mr. Shukla emphasized this is a letter by the NCTE. They should have issued a notification and all that. So now the first page is referring to some direction received from the central government. Now, Lordship may come to the 179, the last paragraph. Keeping in view of the above, it has been clarified that the NCTE has already decided to accept the verdict of the Lordship, I'm sorry. This is going on. Patna High Court in the case of Sanjay Kumar and others, therefore, this is very important, you are requested to consider all those candidates who have completed DLED course of NIOS and may be given opportunity to apply for fresh recruitment. Here the recruitment pertains to 2020. So it will become prospective in the worst case. It will not be applicable to the advertisement, the recruitment which is already in process. It's for the fresh recruitment. Now, Lordship may have. Why are you arguing that point?
ये तो बुद्धि खराब है ना ये वो करो
They are
यार
lying on it. It's for the fresh recruitment, not for the recruitment which is already under.
Yes, means if they are qualified for fresh recruitment, why not make them qualified for
No,
the
because
pending ongoing?
in that case, 70% has already been appointed. The Lordship may. You are arguing against you. Lordship may have page 37 of the June judgment. Just 2 lines and I'll complete it. Requires Lordship, because initially Justice Gawai at the outset and thereafter Justice Misra also said about it. This regulation 23(1) is very important. Page 37, top. Regulation 23(1). Page 33. Just the same. Any person possessing such minimum qualifications as laid down the academic authority authorized by central government by notification shall be eligible for the appointment as a teacher. Now the NCTE Council tried to place the lines on the government direction under 20A in the communication of 2017. 2017, where they said that the central government has empowered them. Now look here, as again, I'm sorry, Lordship, I'm repeating myself, page 164. It is clarifying 2017's communication. Lordship, page 164 of my paper book. Javis. इनका कौन सा? 6th of September. अब पे नहीं है. मेरा this is my paper book is this is very important. This is not in Mr. No, it is not. Lordship may have it. Why don't you people provide? In any case, Lordship is a co-passenger. I am the one who prepared that when the state came later and then joined the issue. Lordship, my one page 164. So the entire submission of the NCTE is taken care of. They rely on a communication of 2017 whereby they said 12A is coming to their rescue and they could have done it. The center, they were empowered.
What is your answer to the argument by the other council that if I am qualified to hold my position as a teacher today, why
That's
not treated as qualified for all?
I'll also come to that.
That was the argument.
I'll also come to that. But it has to meet the legal requirement.
That is subject.
Yes.
And on date, on this qualification,
But the state,
why not he is qualified?
but the state is not considered because our service regulations don't permit this. For us, Lord, 2 years plus 6 months training. That is the basic which we require for our purposes for the state.
That was the challenge.
That is as per the.
But precisely that was the challenge. You may not recognize.
No,
But that is the challenge here.
no, there is a basis why we say this. Our service regulations are based on the NCTE regulations which were notified. till today, this NCTE has no regulations framed. They have not issued any notification under Section 2J of the RTE. Unless they issue a notification, then the state will consider. Today, we consider only 2 years plus 6 months as the basic, which we require for our state. So whether a person is qualified or not will depend upon not as the induction policy for our state. We only want 2 years plus 6 months. If they do not, they are only entitled to remain in service.
For releasing grant in aid,
Yes.
you will treat these teachers who are working in the aided school
Yes.
as a validly appointed and fully eligible teachers, yes or no?
Yes. Yes. Quite.
Then
Only
they are eligible teachers
relaxation
for purposes of grant in aid.
It is only for them to retain the post, no further promotion.
Yes.
No further promotion. They will not be entitled.
The Lordship, this is the last submission. Lordship, I have 164. That means the NCTE's submission to the court. They are relying on a 2017 communication which empowers them to do it. Now, Lordship, I have 164. The 17 stands clarified. 1 minute.
$164.
Yes, that's my paper book. They are busy. Lordship is having this. Yes. Justice Gai probably is. Lordship.
His paper.
Lordship may come straight away to subclause 2. As per the NRC NCTE order dated 22nd of September, the one which was read out to the court by the NCTE Council. 17. The DLED ODL program, they are not calling it any other concept of program. NIOS is only for those untrained teachers.
This is already read in the morning.
No. What are they saying? Because they cannot bank on 17. It's clarifying 17, but NCTE was banking on. Underscore pointed the duration is 18 months. Hence, next one is very important. For the plus appointment of teachers of primary and upper primary level, the notification dated such and such, 10 and 11, need to be strictly added to TET also primary 2012. This was never put a challenge to. Advertisements were never challenged before the court. They waited for 3 years. Advertisements were put way back in 2020. 70% success has taken place. They had no grievance. It's only they come in picture post this NCTE's circular, which is not notified. And 23(1) requires them to be notified. And the High Court, in its wisdom, says it is not required to be notified, while making a reference to the section 23(1). And it still says it's not required to notify.
So this was in 2019.
Yes.
But thereafter in 2021, they say that allow all of them.
There is no notification.
This is also not a notification.
This is
also a clarification.
No, it is saying that what has been notified, the regulations stand notified, they will only be added. The regulations will be added.
And every decision is taken by, we don't know who is taking the decisions. His undersecretary is writing all the time letters. Such important policy decisions.
It's a communication.
Undersecretary is writing letters all the time.
It's a
If we drawing the letter.
Government department, it's always undersecretary or joint secretary, who always say, I am directed to.
It's a communication. At which level the decision is taken?
Rules of business and law.
Top level, at which level? He is not saying I am directed to say by the.
But that is why we also have this difficulty. When a letter comes.
You also issue therefore one letter in January, another letter in February, and third letter
you write to us, central government has
creating a mess.
All right. Then we realize it is contrary to our rules. So therefore we withdraw it.
Thanks lots.
The letters are by additional secretary. Anita Karan is an additional secretary at page 170.
Yes, we have seen.
She is an additional secretary. She's a
GOI letter.
Yes, ma'am. The Government of India letter. She's an additional secretary. She's not a.
Thanks.
You should have argued before they began. Where are you?
I was actually
Waiting for?
seniors to conclude.
Following.
Mr. Sodhi was also.
Seniors of this side or seniors of both the sides?
Both the sides.
Both the sides. It is not the.
Hello, sir. I'm sorry I was not here. I had a matter which was specifically fixed at 2 o'clock for a settlement. So therefore, I had thought my learned colleagues will take some time. I just wanted to show one page and I'm leaving it there if my lords will allow, only if my lords feel it.
Yes.
My lords, I have the certificate that is issued to me, which is at page 235 of that paper book. It categorically records delegation. It's page number 235. It's of the same paper book.
Yes, Javier paper book.
My lord Nandan Singh Johara.
This first half you
Additional.
This is the first half you referred to the other paper book.
My lords, can I just pass it? It's an additional document in the first matter. My lords may not open it, but it is there at 235. My lords can make a note of the page. My lords only look at this. It's additional documents. My lords may look at this. Please don't trouble yourself, because I only want to show that when I get a certificate, this is the kind of certificate that I get, and it clearly records it's a diploma. Now, once it's a diploma, then I am qualified like anybody else. It's not a relaxed, or it doesn't say that I am I am a person who has got it because of any relaxation. Diploma, my lords, is a diploma. And the qualification becomes equivalent.
What happens to their service rules and regulations?
My lords, I would say, let me answer that. The regulations, it has been shown by my learned colleague. I have shown the code page number 160, and this was amended again in 2019, which is at page 174. But my answer to this query that my lords put to me is this. My lords, we were in service. It is this particular qualification that enables us to continue in service. Now, I say this, that if as per your regulation, I am fit enough to continue in service.
If they, as per their regulation, they say that they want a minimum 2-year diploma.
Yes. Then, my lords, they should have removed me from service. Then they should have removed me from service at that time.
Let that concession be arguing, we'll do it tomorrow.
My lords.
What are you arguing?
My lords, I am putting it. Pick and choose.
Are you arguing with serious?
My lords, they can't pick and choose, is what I am trying.
Are you arguing this with real seriousness?
No, my lords, I am putting it as a thing that if they claim that my diploma is not a diploma that the state accepts, then my lords, I qualified in 2015.
Thank you.
I have continued till 20.
Thank you, madam. Thank you.
I have continued till 2023.
Thank you very much. If you want, we will hold that.
Well,
the state would be at liberty if everybody agrees.
I am not.
We'll hold that the state would be at.
Let me say, I put myself that question, that you continue a person on the basis of.
That is because of the policy of the central government. Because of the intervening circumstances on account of.
I can't put it beyond a point that once the central government recognized the qualification as a
for the purpose of continuing into services.
No, that's not stated anywhere.
If you read that HRD direction, it is stated at more than one places.
Well, it's
that only in order to protect your services and in order to ensure that you are not thrown away on the streets.
My lords, I will end it by saying that I make submission. My lords, I just make a submission.
If Mr. Khurshid, Mr. Sodhi and if Mr. Shukla agree that we will hold that the government cannot discriminate and the government will discriminate them being disqualified.
I only want to put this, that HRD letter which has been issued records also the aspect, apart from my lords what they say, it says that these people have to qualify. It says that they have to get a qualification.
Qualification so as to continue in their jobs.
Exactly. So I'm grateful. If I have to get a qualification to continue in the job, and I acquired that qualification, then my lords, subsequently after acquiring that qualification,
Madam, continuation in the
I may not be treated differently.
Continuation in the same post and applying in response to the advertisement are two different things.
So my lords, only one last submission and I'm putting it there. Because the MHRD letter and the NCTE treats the teachers without qualification in the government, in the aided and in the private school at the same level. So people who were in the government schools without the qualification could continue. I only make a submission for your consideration this wise, that once I have acquired that qualification and I will be in private school, I would be then entitled to consideration also by a government school, because it applies equally to all teachers who did not have a qualification, irrespective of the fact whether they were in the government school, in the aided school, or in the private school. Once they acquired the qualification, then when was today, the teachers who were in the government school continue. But it is being said that we who are in the private school now cannot seek adjustment or consideration to participate in that examination. So my lords, we are not getting in automatically. We will also go in a competition along with all others. Only thing is our zone of consideration and our eligibility. The only thing is zone of consideration and eligibility at this stage.
Yes.
And my lords, if we qualify that and we have this, then I only respectfully submit that please do not treat us differently from our colleagues who by virtue of the same qualification are continuing in the government school. By a fortuitous circumstance, at that point in time, we were in the private school. Having got that qualification, we want to improve our future by participating in a competitive exam. My lords, that is my respectful submission, and that's only on that principle of Article 14. Please treat us equally as all others. That's it.
My lord, may I submit on behalf of the region?
And what is the finding of the Patna High Court? There is absolutely nothing.
My lords, Patna High Court holds that the 18 months, that was a sort of thing that was urged also in Patna High Court. They said it's approved. Can I show that observation of Patna High Court? Here's my note. I'll just give my lords the page of Patna High Court judgment. Would my lords come to page 222, my lords, towards the page 222. After going through the entire this thing, the material that we have also placed before my lords, paragraph number 14, from where perusal, it is apparent that NCTE recognized one time the course in Deled conducted by NIOS. The relaxation of period was only granted in service teachers who had not obtained required degree training, such as Deled, which made a minimum requisite qualification for appointment on post of teachers in elementary and primary schools. Thus, it cannot be said that teachers who had obtained Deled through NIOS and any other institute duly recognized by NCTE is not at par with the 2-year period Deled course as prescribed under section 23(2). This is the finding, my lords, of Patna High Court, and then Patna High Court goes on to hold further. If we may go a little further, it appears that NCTE has simply informed Additional Chief Secretary Education by way of clarification that as per NRC order of 22/9/17, Deled ODL program of NIOS is only for untrained in-service teachers in government-aided, private unaided schools appointed on or before 10/8/2017. But it is nowhere mentioned that the said course cannot be treated at par with the 2 years training course and on the basis of such direction 2-year degree course, whereas the same course was duly recognized by NCTE in pursuance of the direction issued by Government of India under MHRD under section 29 of NCTE Act. My lords, now that my lords have seen this, please see Tripura for a minute. My lords will find
Tripura, we have seen Tripura also relies on this.
my lords, at 241, 237 and 241. 237 and 241. Apparently, I don't have Sarna here. Mr. Masadik. So, my lords, page 237, paragraph 15, my lords have that. From the above material, my lords have that. The body authorized to prescribe, that's NCTE, minimum standards of education qualification for trained teachers, and one authorized to prescribe the minimum norms for imparting education in such program has recognized the ODL program offered by NIOS for Deled course. This was subject to certain specific conditions, including that the duration of that program would be 18 months instead of 2 years, including 6 months of internship. The background leading to such recognition order would indicate that such limited relaxation was granted in the duration of the course, particularly bearing in mind the decision of Government of India, Ministry of Human...
Thank you.
My lords, then just page number, if my lords would like to see, page 241.
We have seen that. We have already seen that.
My lords, very well. I leave that there, my lords. My lords, I would only respect that we believe that we have that qualification, and I would request my lords to consider that once we are qualified, all of us, and we continue in service, we are recognized for continuing in service.
Then what happens to the advertisement, the rules regulation, which prescribe that the minimum course has to be of 2 years?
My lords, that my lords,
Is the employer not entitled to prescribe a better qualification
so my lords,
than even the prescribed by NCTE?
yes, my lords, now there I want to show the previous judgment of the Uttarakhand High Court of Justice Joseph, as he then was, page number 148 at page 150. This,
Forget about those judgments.
my lords, no,
We are not bound by the judgment of the High Court.
my lords are not. I'm only persuading. This is Justice Joseph's judgment as he then was.
Does that make it a difference?
No, it does not.
Justice Gavai's judgment as High Court judge, or Justice Mishra's judgment as High Court judge after judgment of the High Court.
I'm only
They are not binding on this court.
my lords, I'm only submitting it as a persuasion to my lords.
Don't go on repeating.
I would not do that. I'm sorry if I took it that way, but just see for the purpose of
the judgment of High Court of Uttarakhand.
my lords, but this issue came up and the state has accepted it. Now, if the state has accepted it and is binding on the state can't take a different position today. That's all that I'm imploring my lords to take a look at it. And the SLP was dismissed against this order.
That doesn't amount to
But for the purpose of persuasion, my lords, I understand, Punay Ahmed, but would my lords look at it in the principle? Because the state accepted this point. It's binding on the state to that extent. I say
what was the issue there?
yes. My lords, here what had happened was, in this particular case, there were students who were again seeking an equality. Now, here the judge court noticed of a higher qualification. My lords, just give me a minute. Yes. My lords, may just take page 150, please. Just forgetting that. Yeah, yeah. Of the state SLP, my lords. Yes, my lords, it starts at 149. And this was again in the RTE. Now here, the petitioners possessed 2-year diploma course. Please see 148. This was the fact. And they had this diploma course from outside the state of Uttarakhand. So state of Uttarakhand said, my regulations...
So they had 2 years.
My lords, but state of Uttarakhand took a position that my regulations don't recognize...
We are asking about the requirement that their advertisement specifically states that the diploma minimum of 2 years.
My lords, that is why when I started my argument, I showed my lords the letter of state of Uttarakhand. Uttarakhand non-suited us only on the ground that we had a diploma course from NIOS. It says we don't recognize NIOS. They don't say 2 years.
If you wanted to say something.
My lord, I gave the basic qualification and the 6 months course also I completed, the bridge course which was there within 2 years. Still, I'm not being considered because the coordinate bench, Justice Dhulia, has passed an order in Divesh Sharma versus Union of India that it is being applied retrospectively. I request the Lord to clarify the same.
No, what has Justice Dhulia held?
In the Divesh Sharma versus...
This is B.Ed. This is B.Ed candidates who are wanting appointment to...
Also, I have...
That is not an issue before us, ma'am.
The clarification of Justice Dhulia's...
Not say, well, you have to go with
Justice Dhulia. Why do you want clarification of that judgment?
I got only 1 minute, Lord. Lordship, one time bound activity or equality education under RTI Act.
How can the matter is over now? So,
Lordship only seeking consider my candidature government primary. school not say. I'm a private school non-aided teacher.
That's just one point.
This will be endless.
No, this, and not on merits, brother. We of course learn from what falls from the court also. Your lordships have seen the judgment passed by Uttarakhand High Court, Patna High Court, and Tripura High Court. In all these three courts, the issue that your lordships today that has been raised during deliberations was not considered. Without prejudice, to what we've argued, your lordships will certainly think over it. Please consider, that if at all your lordships take the view that that goes against us, may consider remanding it back also, because I understand that your lordships have heard it, for some time, but today, we are at a situation where the High Courts have not even considered this aspect of what was the purpose of this particular meeting.
That's all I vacancies, my lord. We are short of teachers. All this.
We live to fight another day, I just want answers.
Thank you. Extremely grateful to your lordship. I'm sorry, we ought to have given your lordship the convenience compilation. I'm extremely sorry. Extremely sorry. My apologies.
So the convenience has given one short code and a state
Comparison of notification of order.
Submissions, my lord, I don't think written submissions I have already handed over.
submission.
I'm grateful. Extremely grateful.
Thanks,